everyone, and thank you for joining us for today's session, where we'll be looking at how practitioners can provide useful reports on title in residential transactions. My name is Stephen Smith, and I'm delighted to be joined as always by Ian Quayle and my colleague Robert Kelly. Good morning to you both.
Morning.
Morning.
Before I hand over to Ian, I'd just like to go over a few items so you know how to participate in today's event. You're listening in using your computer speaker system by default. If you would prefer to join over the phone, you can just select the telephone option in the audio pane and the dial-in information will be displayed. This is toll-free, so it's just your local charges that would apply, if any. You will have the opportunity to submit text questions to Ian by typing your questions in the question pane of the control panel. You may also send in your questions at any point during the presentation, and we will collect these during the end as a designated Q&A session. You can also raise your hand during the presentation if you're having any difficulties with the sound or any other technical issues. If you contact me, I will be able to speak to you over the chat box feature, and hopefully we can resolve any issues. Finally, we've included the notes for today's session in the handout section of your control panel. If you're having any issues accessing the notes, please let me know through the chat or the Q&A section, or you can send me an email and I will get these sent over. If you respond to the GoToWebinar emails that you've been receiving, that does come directly to me. So please do get in touch if you would like a copy of the notes and you can't access them. Anyway, I will now pass you on to Ian for the main part of today's presentation. Thanks, Ian.
Thanks, Stephen, and thank you everyone for coming along. Just as I was listening to Stephen there, I was just sort of contemplating the last few weeks, and I was telling both Stephen and Robert that I've been on my travels a little bit over the past few weeks, and it's amazing talking to firms and actually going out and seeing firms, etc., the positivity that is shown to Stewart Title, in connection with their assisting the profession with regard to events such as this, but also quality of product. So it's very nice to hear, and I was telling Stephen and Robert, how impressed I was on the fact that totally unsolicited, I was getting this sort of feedback. So again, thank you to Stephen and Robert and all at Stewart Title for doing these sort of events and helping me to explain my limited knowledge about conveyancing to practitioners who are willing to listen. And also anyone that hasn't had a look or spoken to Robert or Stephen or their team about Stewart Title products, please do so. Because as I say, the feedback I get with regard to support, with regard to product, is very positive. And it's not a question of people telling me things that I want to hear. It's totally unsolicited sort of comments, explanations, etc. about Stewart Title, which is lovely. Anyway, enough of that. Reporting on title in residential conveyancing issues with regard to the provision of information, explanation, advice, and obtaining instructions from clients. The reason that I've sort of decided to do this presentation today is because I'm being bombarded with requests for information about what reports on title should contain, about whether or not it's possible for information to be migrated electronically using artificial intelligence into reports on title, etc. So there are some pretty exciting times out there with regard to the use of reports on title. So it's interesting in that there is an appetite, as I say, for changing the way reports on title are produced. That of itself is good news and interesting, but it also generates dangers. So there are opportunities and there are also risks associated with changes in practice and procedure. It's also, I think, useful to have an overview of what we should be doing with regard to reports on title and where things can go wrong. So as Stephen kindly mentioned, there are notes that accompany today's presentation. In addition to that, we will have a question and answer session at the end of the presentation. If you want to see a model form of report on title, then the Law Society's Conveyancing Handbook has a form of model report on title that's useful and interesting. I would have to say to an extent it's incomplete, and I'll explain why as I present today. If you're doing commercial work or you want to look at a more sort of commercially orientated form of report on title, then I think you can go no further and look no better than at the City of London Law Society's short form report on title, which you can download from the City of London Law Society's Land Law Committee website, which hopefully you've seen in the past, or hopefully you could have a look at in the future. So, useful website, Property Litigation Association website contains a wealth of information about some of the things I'll be talking about sitting behind the content of a report on title. Remember, I've mentioned to you property protocols and the boundary dispute protocol. Again, if we've got a boundary sensitivity that we're dealing with in a report on title, we can look at that advice that's contained on that protocol that is useful. The RICS, remember, has a consumer guide for surveys and valuations. Stephen, I do hope that everyone has now had a look at that consumer guide and utilises it. It's important because it helps clarify the position, provides additional sort of third-party advice as to the benefits of survey and valuation. And of course, if we're dealing with leasehold transactions, then the Leasehold Advisory Service website and the Leasehold Knowledge Partnership website contain material that will be useful for us. Finally, the other sites are all free to access. Finally, and again, I'm delighted to say that Stewart Title is supporting this. I acquired a publication called Property Law UK that produces a monthly newsletter highlighting key issues for residential conveyancers and indeed commercial property lawyers. You do have to pay for it, unfortunately, but it contains a wealth of information, some interesting articles from Robert Kelly of Stewart Title, and every now and again something that's meaningful and useful from me. So enough of all of that. Let's talk about what I really want to get down to in the nitty-gritty in connection with producing reports on title. There is guidance from the Law Society Conveyancing Handbook that I think is quite interesting and is quite useful to sort of share. And one of the things that's emphasised there is that the report should, in essence, refer to all the investigations that are undertaken by a buyer, solicitor or conveyancer. And this is the thing I want to major on at this point, an explanation of the process of due diligence and the conveyancing process that the client can understand. Important to understand and appreciate with regard to that, therefore, that suggests that we can't have a standard report with standard wording that we utilise, in that we've got to ensure that the reports that we are producing are capable of being understood by the client. Again, I quote, we're reporting to the client in language relevant to the client's level of understanding. Now, I have acted for clients over the years, and I'm sure I'm not that unfortunate. I'm sure we've all can share some experiences with regard to clients where their level of understanding, as best I can state, isn't great. And therefore, do we have to produce various types of report depending on the level of understanding of our clients, or do we sort of proceed on the basis of the lowest common denominator and produce reports on title with wording that the clients that are likely to have the least knowledge or the least ability to understand a fighting chance of understanding what we're saying? Got to be careful about that. Again, we've got to be careful, I think, about legalese. And I think I've reconciled this by saying, well, all right, yeah, we don't have a report on title in which we scrutinise the wording so it fits the client's level of understanding, so each one is personalised. I think what I have concluded is that we don't use legalese. We try and explain to a reasonable level what a layman might need to understand or appreciate. So bearing that in mind, then, let's have a look at what our report on title should contain. And first of all, perhaps looking at the title of this slide, ask ourselves what we shouldn't be doing. And the most important thing, I think, here, and a serious lesson to be learned, is that a report on title is not just a transmission of information. So it is not 5 or 6 pages and then a wealth of annexes or appendices where we're sending searches, we're sending in the leasehold transaction a copy of a lease, we're sending TA forms, transfer and contract, and basically saying to the client, read that and let me know if you have any questions. I think there is a place for the provision of information, but there is certainly a place for explanation and advice, and the result of a report on title should be a level of understanding for our clients and an ability for our clients to have informed consent, leading to an ability to advise us that the client is happy to proceed with regard to the transaction. So, bearing that in mind, then, let's just have a look at what our report on title should contain. It should contain the results of the investigations which have been undertaken on behalf of the buyer, the searches, the inquiries, the additional inquiries, the information that is generated as a consequence of sight of title. We should be disclosing and explaining to the client the terms of the contract. Now, a word of caution here. Historically, I have seen some firms that attempt to translate each and every standard condition of the contract for the client. I think that's unnecessary. I think there are terms of the contract that should be explained to the client, notably with regard to insurance, notably with regard to the limitations concerning misrepresentation and state and condition of the property. I am mindful of the fact that historically, in previous forms of standard conditions of sale, the Law Society used to produce client guidance notes. That's no longer possible. And I also remember that a pal of mine at one stage was able to recite each and every standard condition in connection with the Conditions of Sale 4th edition that some of you may recall. He was absolutely devastated, of course, when the 5th edition of Conditions of Sale came out, and therefore his party trick was sort of blown to the wind, as it were. Not necessary to do that, but I do think it's important that we highlight to the clients the key terms of the contract, certainly highlight to the client special conditions that we encounter, and any conditions that are pertinent or relevant to client objective. And remember, if a contract is varied, whether it's varied and a new contract is drafted, whether it's varied longhand as a consequence of amendments that are made just as we're about to exchange contracts, or amendments made or variations made by way of side letter or collateral contract, the client needs to be made aware of those variations. Which leads me to an important point that a lot of practitioners forget about. Once we've submitted a report on title to the client, don't forget that things could happen with regard to the transaction that would warrant an addendum or additional comments or additional advice. So just because I've submitted a report on title to the client and I'm about to exchange contracts or contemplate exchanging contracts next week, if something is drawn to my attention in the interim, remember that that information needs to be transmitted to the client and the report on title amended, or the client made aware that the content of the report on title changes as a consequence of the change that we've been notified or that we've identified. In terms of mortgage offer, and I think as well, particularly if we're dealing with first-time buyers, etc., the obligations that are owed by the client to the lender. So not just the peculiarities of this particular mortgage offer, but the status of the mortgagee and mortgagor and the duties that are owed to the lender. Survey or valuation, I think, is important. And again, not just providing the client with a copy of a survey or valuation, but also providing the client with an explanation of any legal issues that are contained within the survey or valuation. Important point here, I'm often asked, do I simply as a conveyancer have to look at the legal issues that the surveyor or valuer generates, or should I look at the entirety of the document? The important point here is we should be looking at the entirety of the document to see if there are any other issues that might impact on what we're saying in our report on title, or indeed our advice to clients. The report on title should also include a summary of conclusions and advice for the client. And here's another important point. I like a report on title to start with setting out client objective and then concluding with how what we've found impacts on that objective. So I would do that within our conclusion. So let's drill down in a little more detail about the content of the report. So I think it should be addressed to our clients. And remember, if we've got a collective client, then the addressee are all the clients that are purchasing the property. We need to assess client objective and list that objective. So why is the client buying this residential property? What is the purpose behind it? And as a consequence of that, we need to ensure that we are directing the advice that we're giving, directing key issues with regard to due diligence to our client and to that objective. We should be specifying the property description. And here's an important point. And again, I would direct you to the property protocols, boundary dispute protocol, in highlighting the potential dangers of how we describe the property, particularly if we describe it by reference to a plan. Remember, we can't utilise a land registry title plan without a health warning. And as far as other plans are concerned, we've got to explain to our clients the potential problems with regard to relying on plans and their unreliability, and particular problems with regard to scale. So remember what I've said in the past about a red line on a title plan. If you scale it up to life size, it becomes a line on the ground that's 1.5 meters wide. Other plans and other lines on things like ordnance survey maps and plans can be a meter, a couple of meters wide, depending on scales. Better, in my view, when we're describing the property, to describe the property as per the contract or as per the property register, providing a plan as an illustration or a guide, but not to be relied upon. As far as confirmation of title is concerned, the easy bit: is the property freehold or leasehold? Is the title registered or unregistered? If the latter, title number and quality of title. If unregistered, perhaps an explanation as to the complexities associated with first registration and the likely delay resulting. If we're advising a client in connection with the leasehold purchase, a very important point to note: we should be explaining to our client not just what the lease refers to, not just the changes in the conveyancing process relevant to a leasehold transaction, but also the bigger picture with regard to leasehold ownership. As far as that bigger picture is concerned, the disadvantage of owning a leasehold as opposed to a freehold, the disadvantage of having to deal with a landlord, even if the landlord is reasonable, the duties and obligations that a lease contains with regard to landlord and tenant leaseholder. Item 5, this is where I tend to sort of diverge from the law society model. The model suggests that we advise the client of the name and address of the seller or sellers. But I think we should also consider advising our buyer client as to how long the sellers owned the property, and if we can, the price that was paid for it. Here I'm sort of giving a nod to risks associated with property fraud. So if the seller has said something to the buyer that's inconsistent with what the title reveals, then hopefully the buyer will notify us and alarm bells will ring across the board. But as far as the Law Society Handbook is concerned, we're simply entitled to advise our buyer as to the name and address of the seller. I then mention what I think are the key issues relating to the report on title. Third-party rights, easements that are benefiting the property, easements that are burdening the property, covenants, restrictive covenants, etc. And here I think there's some important points. Where we've got an easement that is essential, a right of way that's our only way of vehicular and pedestrian access to the property, I think in the report on title we should be clarifying that we've investigated to determine that the easement is in fact enforceable and has in fact been properly protected. If, on the other hand, there are easements that are not essential for our client's purpose or objective, then we simply advise the clients that the easements exist and have been granted, or easements have been reserved. Important point here, and again this is significant: where we have easements that are registered, the burden of easements that are noted on a title that our client is acquiring, the fact that the land registry has registered the easement or noted the easement on the land that is the servient title does not all of a sudden and automatically legitimize the easement. So it may be necessary to advise our client that we haven't carried out investigations to determine that the easement is in fact enforceable, or it may be appropriate to tell the client that we have in fact performed that task and we are able to confirm insofar as we can that the easement is enforceable and will allow our client to undertake whatever they wish to undertake with regard to the property. So as I mentioned in the notes, we should be looking at third-party rights, whether those rights are enforceable and if so against whom, or if there are rights such as easements that have been reserved over the land that we're acquiring, who can enforce those rights against our client. As far as purchase price is concerned, again, fairly self-explanatory. I might, and in fact I would, advise my client where a purchase price is being apportioned, that apportionment must be fair and reasonable, and that apportionment might have implications with regard to SDLT liability. The deposit should be specified, and significantly, how the deposit is to be held, the obviously agent or stakeholder point. Something that the Law Society's model form of report on title doesn't deal with is the situation if a reduced deposit is paid by a buyer. And I might, given the defensive so-and-so that I am, think about advising the client about the fact that if they default with regard to completion, that they would be obliged to pay the balance up to 10% at completion, even though the buyer is unable or unwilling to complete. So I might just add that in the report just for sort of clarity, and just so that my buyer client understands that where a reduced deposit is agreed and the accommodation in essence benefits our buyer client, the downside is if we are unable or unwilling to complete, we're going to have to pay the balance at completion, even though the circumstances will be that perhaps we have no intention or we're unable to actually complete the transaction. The Law Society's model form of report on title suggests, quite helpfully, that we should specify any unusual or important terms contained within the contract. So are we just contemplating special conditions here? Probably, but I would class as provision with regard to insurance as being an important term, and also issues with regard to state and condition of the property, particularly if it's empty, as being important. Mentioned already the mortgage offer, the terms of the mortgage advance, including mortgage conditions. And I would, as I say, if I haven't already, advised my client about compliance with the terms of the offer and the risks associated with default in connection with the agreement that the mortgage deed refers to and the obligations that are owed to the lender. Issues relating to insurance, etc., and in particular the issues relating to the duties that are owed to a landlord in connection with a leasehold transaction. We're obliged, I think, to provide our client with information provided by the sellers and the TA forms. Again, being defensive, I might suggest that if the seller, in fact, does not tell us the truth, or is negligent, or makes an innocent mistake with regard to the information in the TA forms, that our real sole right of redress is likely to be an action for misrepresentation. And again, I may say to the client that they may not have the appetite, nor indeed the resources to pursue such a claim. So that would reinforce the point that I would make to clients about ensuring that they use the TA forms as a checklist. Planning status of the property, and in particular whether the current or intended use of the property is authorised. Very important point, sometimes overlooked in reports on title. And again, reports can frequently lack detail about planning conditions, building regulation consents, planning agreements, community infrastructure levy that could affect the property. There may be other issues that additional inquiries of the local authority would reveal with regard to roads, and issues associated with roads. And again, in those circumstances, I would be advising clients about issues that are generated courtesy of replies to additional inquiries. And again, something I'm working on at the moment, which is quite interesting, whether or not we should be advising clients to instruct us to obtain the CON29 optional inquiries. And again, interesting, when looking at what the Law Society guidance is, the point there is that such inquiries are not essential, that whether we use them or advise our clients to obtain them depends on the circumstances in each case. Certainly I'm doing some work at the moment that would suggest if we're buying a property in a rural area or buying a property where there is sort of open land in the vicinity, then question 4 of Con 29.0 perhaps becomes significant, because there may be schemes with regard to the highway or private roads, such as accesses, such as park and ride schemes, etc., that might impact on the value of the property that we're acquiring or client's use and enjoyment. Of course, if we're buying a leasehold property, then our report on title needs to contain details of the lease. And again, this isn't just the provision of information, read the lease, but this is a sort of translation of the duties and obligations that the lease contains. We should advise our client of the name and address of the current landlord, details of service charge, management regulations, and other relevant management information. Remember, in the past, I've spoken to you about the use and the benefit of the leasehold advisory service guidance about owning leasehold property, and referred to that the Association of Residential Managing Agents produces a similar leaflet. It may well be worth providing the client with a copy of one or other of those documents. As an aside, I've just recently seen that the Association of Residential Managing Agents also produces a leaflet for clients on estate rent charges, which again is quite interesting and quite useful. So if there are estate rent charges payable in connection with a freehold acquisition, it might be important to explain to the client the consequences of an estate rent charge and advise our client about the implications of such an estate rent charge, and the Association of Residential Managing Agents guidance note or leaflet might assist in that regard. Item 16, information and explanation of insurance arrangements. We might want to limit the scope of our retainer here, explaining to the client that we won't be giving advice about insurance product or suitability of insurance or comparisons with regard to premium. It is for the buyer to deal with that, but it is our responsibility to advise our client whether it's necessary to put in place an insurance policy at exchange or at completion. Again, if we look at the Law Society Conveyancing Handbook, we're told that we should advise clients about a summary of significant issues, such as breaches of restrictive covenants, etc. Well, again, as far as that is concerned, what do we mean by significant issues? The Law Society suggests things like breaches of covenant. Well, again, yeah, a breach of a restrictive covenant is certainly going to be more than significant in my view, and potentially could be a deal breaker, so certainly would need to be highlighted. But what about other issues? Well, I think anything that's relevant to client objectives should be explained. Item 18, details of issues relevant to title revealed by the buyer during the buyer's pre-exchange inspection. This is something that's got me quite worried, to be honest with you, with regard to the production of reports on title using artificial intelligence. Because whilst it's perfectly acceptable, reasonable, and potentially advantageous for a report on title to have migrated into it, search results, information from the land registry, etc., freeing up a conveyancer's time to perhaps personalize the report or to think about other issues or to report to clients some of the points that I've just mentioned. One of the sticking points, I think, with regard to any form of automatic transmission of data into a report on title is that we're potentially going to miss information that can only ever be revealed by the buyer as a consequence of the buyer's pre-exchange inspection. And when I start thinking about that, I also think about my experience when looking at reports on title generally, and the fact that frequently a conveyancer fails to explain to a buyer client anything that has been revealed by the buyer during their inspection. So I think there's a weakness here. And it's a weakness not necessarily in the report on title, it's a weakness in the conveyancing and due diligence process. We're advising clients to inspect target property. We're telling client why they should inspect. If anything is revealed during that inspection that impacts on title, and here I'm immediately thinking about overriding interests, those issues need to be included in the report on title because our buyer client will be bound by them. 2 or 3 points that I think need explaining here and exploring here. One, remember, a buyer is bound by anything that they see during inspection, but also anything that they ought to have seen, the idea of constructive notice. Do we tell our clients about that? Do we explain to our clients that if they don't undertake a reasonable inspection of target property, and there is something that a reasonable inspection would have revealed and would be binding on them, then they're bound by it? I'm thinking here in particular of potential problems with regard to prescriptive easements, so rights of way, etc., that are obviously overriding interests and are obvious on inspection, or perhaps overriding interests that are not so obvious. And again, I've spoken to you in the past about this. If there was the slightest hint that my client was acquiring a property and there was a suggestion that there was a prescriptive easement over the property, or there was land adjoining, and it appeared that there was some form of informal rights of access and egress along that parcel of land, I would be wanting my buyer client to ask neighbours and to extract from the seller any knowledge or any awareness of use. And that information then, of course, is no use simply in the hands of the buyer client, but needs transmitting to you. As a consequence of this, I've drafted a sort of little client sort of questionnaire that I think might be useful in circumstances where we're suspicious of the existence of prescriptive easements or other overriding interests, so that we're highlighting to the client, if they see anything that they are suspicious of, they should be reporting that to us. Item 19, of course, relevant to today, details of any defects in title and explanations of the use, benefits and limitations of defective title insurance. Again, this is something that the report on title produced by the Law Society and the Conveyancing Handbook, I think, doesn't really address. Certainly, if we're taking out a defective title insurance policy, we should be providing an explanation as to why that policy has been taken out, its benefits and indeed limitations. Robert, if you could just share with me for a moment or two, if possible, your views about this. It would certainly make sense to me that a report on title should explain that it's been necessary to take out a policy and what that policy does, in addition to advising my client separately by way of email when a policy is required and when a policy is taken out. What are your views?
I think you're right, Ian, that it needs that two-prong approach, because it's very simple to say to a client, we've identified this problem and we've solved it by getting insurance, which isn't the full story, as we've said before. So I think it's worthwhile, but you do need to be aware, by going down the insurance route, you then get covered by the Insurance Distribution Directive and have obligations there to report to the client. And so there's a lot of words could go into a report. So I think you're right to try and separate it in that way, to highlight that there is a solution available through insurance. But obviously, also, as we've said in previous webinars, explain what the insurance does, that it is ultimately a financial compensation, diminution in market value. And if you want a 4-bedroom house, the fact you're going to get the diminution in value isn't going to help you. So it's one of those areas, really, like you've been saying all the way through, where the duty is not just to point out the legal problems, but to understand how they affect your individual client and their personal use and enjoyment.
Yeah. So, Robert, would you agree with me that when we're taking out a policy, we do all that's necessary, as you just mentioned, from a compliance perspective, explaining about our role in connection with the obtaining of the policy, and advising the client about the duties and responsibilities at that point in time, and that we're simply in the report on title sort of dealing with slightly different issues, as you've just mentioned, explaining what this policy does, and in fact also explaining what it doesn't do.
Yes, I think that's right. I think there's probably it's worthwhile explaining it at this time, and then making a note to remind the client at completion or at exchange of the obligations, the ongoing obligations, when you've got the benefit of insurance. And as much as you can to explain what policies do. I've said to you before, we get quite often members of the public ringing up and saying, I've got a chancel repair policy here. does it cover the fact that my French window's just fallen out and things like that? So
Yeah,
I think there is sometimes a lack of explanation to clients there, and it's worthwhile
yeah.
ramming that home, because if they misunderstand and they can't make a claim on the policy, they're quite likely to come back against the lawyer.
Absolutely. Good point. And the other thing, again, that I would say, just for delegates that are listening, when you're concluding your retainer and closing the file, if there is a defective title insurance policy, again, I think it's worthwhile just reminding the client of its existence, and just a sort of line or two explaining about the fact that if they become aware of anything relevant to the policy, that they should be notifying the insurer and reminding them of their duties not to disclose the problem or indeed the existence of the policy sort of going forward. So thanks for that, Robert. Yeah, I think that's significant and relevant. Co-ownership. Again, I think that we should be explaining to clients, of course, that are buying as co-owners, the nature of co-ownership, the manner in which they have instructed us to hold the property, and the potential problems associated with it. So I was doing some training last week talking about co-ownership, and one of the things that surprised me, to be honest with you, was that there was a failure to give advice to clients about a joint tenancy in connection with the availability of a unilateral severance by one against the other, with the sort of other party having no choice in the matter, and also the potential circumstances of death arising from joint accident. So both joint tenants die in the same car crash, God forbid, and the fact that the younger is deemed to survive the elder, meaning that that could have implications if they have different beneficiaries courtesy of their wills. So choice and advice in connection with co-ownership, I think, is important. Again, the issue of co-ownership, the choices available to the client, the advice that is given in connection with co-ownership, I would deal with separately, but I would cover off what choice has been made and what advice has been given in the report on title. Another interesting thing I've just been doing some work on over the weekend. Gosh, I always sound sad, don't I, when I tell people I work over the weekend. But anyway, I was, and I did. And what I found was there's been quite a bit of case law where co-owners don't sign the transfer. And the problem that can arise is if there's an argument about whether or not the transfer in fact accords with their instructions and their intentions, what do you do? And unfortunately, my research doesn't reveal or provide any useful conclusion, all other than make sure that if your clients are buying as co-owners, they sign the transfer. And I think it's always worth pointing out to the client when they're signing the transfer what the co-ownership provision in that transfer is, just in case there's a mistake or a confusion that could be clarified at that point. Item 21, straight out of the Law Society Conveyancing Handbook, limitations relating to conveyances liability. What I think we do here is we look at the report on title in tandem with our engagement letter. We're drilling into clients the fact that there are limitations with regard to the conveyancing process, limitations with regard to searches that I've bleated on about on a regular basis whenever I can, the fact that a conveyancer hasn't inspected the property, the fact that a conveyancer is in essence reliant upon the buyer's inspection and survey to reveal issues that wouldn't be revealed courtesy of an inspection of the title or disclosure by the seller in the TA forms. Additional limitations, I think, important relating to the conveyancer being unable to advise on contamination issues, physical state and condition of the property, or value issues. Flowing on from that, I think there are other points that are worthy of investigation, namely issues associated with the fact that searches are from time to time defective, that as far as searches are concerned, they have their limitations. So all of those things should be, I think, explained to the client when we're explaining the conveyancing process generally, and when we're providing a report on title to our clients as well. The idea of a summary or conclusion highlighting key issues is a double-edged sword in my view. There is a danger that if I provide a summary to a client, that's all they're going to read. And there is a danger then if at a later date the client said I wasn't aware of this or I wasn't aware of that, The client then says, well, yeah, I didn't read the main body of the report. I just read what was said in the summary that might generate a bit of vulnerability for us. So I think if we're going to provide a summary or conclusion highlighting issues relevant to the objective, we spell out in bold print or different colors the fact that the client is required to read the entirety of the report, that each and every item within the report is equally important, but that we have considered there are certain issues that are worthy of repetition given client's objective. I think if we do that, then we're moderately safe. Item 24 in my report at page 6, top of page 6, I think we should be explaining to clients the we've done that before, the elements of the conveyancing process, and either or done that during or we do it. I'd rather us do it out with the report than within it, because if we're doing it within the report, we're getting to the realms of producing a bulky report on title that the client won't read. Before I leave this section, there are 2 points that I want to make. One, I think I've now reached the conclusion that instead of producing one report on title at the end of the due diligence process, as we're about to exchange contracts, a sensible approach is to produce interim reports. So when we've received the contract bundle, we produce a report on title on what that contract bundle reveals. When we've got survey, when we've got mortgage offer, we produce an interim report on that. So in doing that, we're breaking the report down into more manageable pieces of information for the client. It might be then appropriate at the end of due diligence to produce a full report, just reminding the client what we've told before and adding some new bits. Before I leave this and start looking at some things in a little more detail, I just want to refer you to Orient Field Holdings Limited against Bird and Bird. I've mentioned this case to you before because it explains what we do with regard to searches. But I've been looking at the case again in the context of reports on title and extracted a number of, I think, important points. That our report on title should include a summary of the effect of a search carried out on behalf of a client, should provide the client with information about further investigations that are warranted, that could be carried out if there are adverse entries or entries relevant to client objective, and that we should be inviting instructions from the client in the light of that summary. Remember what I've said in the past about searches and adverse entries. We report to the client that there is an adverse entry or an entry relevant to objective. We explain to the client what further investigations are possible that we can carry out or that the client can carry out, and then we ask for instruction as to what the client wants to do. Where the client is carrying out their own investigative work, it might be prudent to determine what the conclusion of that investigative work is, and it might be that we add that or incorporate that into the report on title. So I might produce an interim report to my client when searches are undertaken. I might be producing a final report, and in that I'm going to summarize what additional investigative work was undertaken by us, additional investigative work undertaken by the client, and the result of that work. In other words, we've sort of identified or limited risk or exposure to our client. Moving on, information, explanation, advice, and instruction. Remember the point that I said right at the beginning of my presentation. I repeat, it isn't enough to give clients information. The SRA, the legal ombudsman, the courts are saying that's not what a conveyancer does. We're not a mailbox. We've got to provide information in combination with an explanation of the information that's provided. We've got to put the information into context, and we are required to give advice to the client. Now, here's an important point. I can't just say this is the advice that you give a conveyancing client, unfortunately. Again, there's a need for personalization. And if there's a need for personalization, there's an understanding or a requirement for an understanding of client needs. So again, particularly where we're dealing with clients at a distance, particularly where we're dealing with clients that we're not going to see, How on earth can we ascertain their objectives, their views to risk, etc.? A difficult one that perhaps requires us to warrant or undertake investigative work when we're onboarding clients. In connection with the giving of advice, again, we're not required to advise clients about issues that are without or outside the scope of our experience and knowledge. So we're not expected to be experts on planning or experts on contamination issues or experts with regard to drainage and water problems or issues. But we are expected to undertake searches that would highlight or reveal problems in those areas and to advise our client where additional information and advice can be sought. I've given you in the notes issues relating to, and this is at page 7 onwards, sort of our role. We're not general advisors. We're not project managing. We're transactional property lawyers. But in that role, there may be circumstances where the deal is so bad, the transaction is so disadvantageous for the client, the risk is so great that we've really got to warn our client about it. And if that's the case, that's where our summary or conclusion of our report on title would perhaps be in a suitable spot for giving that warning or repeating that warning. I mentioned the duty to explain in the notes. I'm not going to dwell on that today, but remember that we should be identifying client objective, we should be providing advice relevant to that objective, and we should be advising clients to exercise caution in certain circumstances. Moving on, if I can, I've given you at page 10 onwards some important points. Firstly, we've got no duty to advise on commercial wisdom or otherwise of a proposed property transaction unless the transaction is so disadvantageous or our client is so inexperienced that it is prudent to give some advice. But the advice should be not don't do it, but get specialist advice to see whether or not what you're proposing to do is wise. Let me give you an example. Let's assume that you know that the market value of a property in a particular locality is £580,000. And yet your client is buying this particular property at £780,000. It's not for you to say to the client, don't do it, but I think it is for you to say, hang on a minute, this seems to be a property that is similar to other properties that are being sold for substantially less. Let's have a look again at a valuation or survey, or let's get another valuer or surveyor in to see if this transaction makes sense and to make sure that this property is worth the price that you're paying. I mention in the notes cases such as Carradine Properties and Freeman, where again the courts are saying a solicitor's duty, a conveyancer's duty is to exercise all reasonable skill and care in and about his client's business. In deciding what he should do and what advice he should tender, the scope of the retainer is undoubtedly important, but not decisive. So the suggestion is that if we're acting on a sale or purchase, we're not obliged to advise our client about an unfair dismissal action, obviously. But if there are unusual covenants or planning restrictions, the court is saying, the judge said, Lord Justice Donaldson, then it may be necessary to warn the client of the risk and dangers of buying the house at all. And again, in those circumstances, getting supportive advice or assistance might be useful in that connection. Just moving on, if I can, I've covered that off. Covered this off. What is a report on title? We've covered it. Might be a series of interim reports. It might be a final report. It can be in a variety of different formats, but it should present to the client key issues that the due diligence process, documentation, and information from the seller generates. It should be flexible, client-facing, and producing information that the client is going to understand. So I go back to the point that I frequently make about effective communication, making sure our clients get the points that we're making over. And it's important that clients read the report on title, understand it, and are invited to ask questions. So when we're submitting a report on title to the client, I would always ask the client to confirm that they've read it, to confirm that they've understood it, and to confirm whether or not they have any questions relating to it. What should be explained to the buyer client, I've covered off, page 12 of the notes, page 13 of the notes going forward. I don't want to dwell on the case law that I mentioned, that's all self-explanatory. I do want to talk about advising on title, page 19. We are obliged to ensure that our client is acquiring a good and marketable title, but I don't think it's necessary to explain to the client what a good and marketable title is, but I've given you the details at the bottom of page 19. I think it is important to determine that if the title is not good and marketable, that is advised to the client. In essence, a good and marketable title means that the seller is legally and beneficially entitled to the property, and that ownership will be transmitted to the buyer at completion. We also need to ensure that from the buyer's perspective, the property is suitable for the purpose for which the buyer requires it. It is important to understand, I think, with regard to registered land, an absolute title and an absolute freehold title may, but may not be, a good and marketable title depending on circumstances. There may be rights, third-party rights, there may be interest in the land that could impact on our buyer's use and enjoyment that mean the target is not good and marketable for this particular client. I mention in the notes that a seller should audit the title before a contract bundle is produced. And I also mention in the notes the important point that when we're undertaking title investigation, we should be aware of property fraud and the risk of fraud. Again, not necessary to sort of dwell on those issues at all at this point in time. What I would like to do now is just skip through one or two points on slide. I've specified if we're dealing with reports on title and investigating TA forms that we should be advising our buyer client of the potential for misrepresentation if the seller is not truthful with regard to responses or is mistaken with regard to responses. We should also be advising a buyer client where we think the seller has misled the buyer with regard to information in the TA forms of the potential of criminality, as I mentioned on slide. With regard to searches, we need to understand and appreciate as part of due diligence that there's no such thing as usual searches, that we should be undertaking essential searches, necessary searches given client objective, property location and nature of transaction, and that where search results come in, we should be advising clients of information that is pertinent to objective or adverse entries that warrant further investigation. We should explain to clients the limitations relating to searches. As far as the contract is concerned, certainly explain insurance, certainly explain completion, certainly explain state and condition of the property. Also, perhaps advise the client about the need to ensure that the contract is compliant with relevant law, Section 2 of the Law Property Miscellaneous Provisions Act 1989. Certainly, we should be reporting to client any special conditions or variations to the contract after a report on title is produced. Word of caution here, I'm not saying that you advise the client and provide the client in a report on title with an essay about Section 2. We just explain to the client that for a contract for land to be legally binding, it must comply with Section 2, contain all material terms, signed by the parties and in writing, warning the client that any sort of informal arrangements, agreements or understanding may not comply with Section 2 and therefore may be unenforceable. With regard to inspection and survey, our client should be told to inspect, should be told why they need to inspect, and should be told to report to us what that inspection reveals. Clients should also be advised about the need, the necessity of having a survey and why, and have explained to them what a survey or valuation actually reveals. Client inspection, remember, client is bound by actual notice, what they see, bound by constructive notice, what they ought to have seen if a reasonable inspection was made. Buyers should be advised that they should inquire of anyone at the property other than sellers what their status is, and again they should be reporting back to you if they discover someone in that context. And again, it's quite important to determine who actually has inspected the property. If we're acting for co-owners and only one of them is inspected, we should be advising the other co-owner of the fact that they are bound by anything that their partner or fellow co-owner in fact saw or ought to have seen. That's me really as far as today is concerned. I could spend a day, Stephen, talking about reporting on title, but I'm sure an hour is more than enough for everyone attending today. But what I'd like to do now is to, if I may, Stephen, open the floor to questions or open the chat facility for questions, to thank everyone for being very attentive, to thank Robert for his input, to make people aware that Stewart Title is there for you with regard to indemnity policies, bespoke policies or standard policies, and that Stewart Title and the team are there to assist with regard to inquiries or further information. From my perspective, if there are questions that you're too shy to raise now using the chat facility, do feel free to drop me a note at the email address shown at the bottom. Provided that you're happy for me to do it, I'll be more than willing to share any responses to delegates that attend via the good services of Robert or Stephen. So I could, if I get lots of questions, hopefully deal with them and provide answers and share them with delegates, provided, of course, the questionnaire is happy with that disclosure. But Stephen, thank you for organising today. Can we have a look and see if there are any questions?
Yes, thank you, Ian. So yeah, we're now going to begin answering the questions submitted during today's presentation. As a reminder, you can still submit any questions you have through the questions pane in your attendee control panel. I appreciate we are near 12 o'clock, but as Ian says, if you have any questions, we don't get around to them, we will try and get to them after today's session. So in the first question today is from Mark Cairns. He asks, where the property has the benefits of an easement, would you check the servient title to ensure that the burden is registered on there? The answer, I suspect, may be that it depends on whether the easement is essential.
Yeah, the general rule, Mark, would be yes, but as Stephen quite rightly states, if the easement is essential for my client's use or enjoyment, or is likely to impact on value, it's a definite yes. So the important point, I think, to understand here is a cost issue. If you are undertaking conveyancing work for me, and there is a right of way that's essential for my intended objective relating to acquisition, you should be checking that that easement is enforceable. So the answer there would be yes. Can you charge for any additional work that you do, Mark? Unfortunately, no. It would be regarded as part of the service that you are providing me. Could you simply say there is a right of way, but I haven't investigated whether it's enforceable or not, I think is dangerous. So where there is a legal easement, I think it is incumbent on you when acting for a buyer to check the servient title to determine whether that easement is noted on the servient title. If I had a situation where the easement, such as a right of way, was obvious on an inspection of that servient title, I wouldn't be quite so worried. Still be worried, but I'd be extremely worried where I had an easement over servient title that wasn't noted on the title, nor was it evident on inspection. But to answer your question, Mark, put simply, I think the answer is yes. And I think, unfortunately, if you do undertake that in additional investigative work, I don't think you can charge the client additional work that you do. I'm assuming in those circumstances is it a legal easement. If it was a prescriptive easement that warranted or required further investigation or clarification, I think there would be justification in charging more. But remember, Mark, if I'm going to do that, I have to tell the client that I'm intending to do additional work and invite the client to confirm that they're happy to pay for it. Great question, Mark. Thank you, Stephen. Hopefully that I've answered that one.
Yeah, thanks, Mark. Thanks, Ian, for that. Just to clarify, Ian, Mark was answering his own question there. That wasn't my comment. But the next question. Yeah. Deanna asks, and apologies because I think I missed this in the presentation here myself, but Deanna asks, where was the leaflet on estate rent charges that you mentioned? I think it was about
the Association of
Residential
Managing Agents, ARMA. If you go on the ARMA website, ARMA is obviously residential leasehold management. So what on earth they've got a leaflet about estate rent charges on the site, I don't know, but it's useful just pointing or highlighting to clients some of the issues associated with estate rent charges. And again, Stephen, I'm a great believer with regard to reports on title or indeed anything else in the conveyancing process to find resources that I can share with clients that are not coming from me because I'm worried about overkill and overload. So instead of me having a leaflet or including in my report on title pages of potential problems associated with estate rent charges, if I've got another resource, and that ARMA guidance would be such a resource, I can provide the client with that, in addition to perhaps a line or two about the potential dangers of estate rent charges. Thanks for that question, Stephen.
Yeah, thanks, Ian. And apologies, I think you cut out slightly when saying the acronym. Could you repeat the acronym again, please, Ian?
ARMA, ARMA, the Association of Residential Managing Agents.
Fantastic. Thank you, Ian, and thanks, Deanna, for that question. Miriam asks, and actually I'd like to bring Robert in on this. Robert and I are having a brief conversation offline about this because although it might seem quite obvious at first, I think the IDD does change this slightly. But Miriam asks, please can you clarify, is it the buyers or sellers solicitors that takes out the defective title insurance?
I think it's
Robert, would you like to comment on that?
It's been split really between the two, and quite often sellers will. And I suppose there is a temptation when you're getting your title pack together, if you see a defect there, to get a policy in place. The problems with that is the issue, I suppose, practical one. Do you know what the purchase price is going to be? We take out the policy for the correct level of cover. But also, who is the policy going to benefit? If you as a seller solicitor try and take out a policy for the benefit of a buyer, there's no relationship between you and the buyer. So you're probably taking on an obligation under the IDD to report to the buyer client about the policy. So it's much better done by the buyer's lawyers, I think, now, because they do have that relationship. And also bear in mind, even if the seller were to take out a fairly generic policy beforehand, which, as most policies will, passes automatically to the buyer, the buyer's lawyer, by telling the buyer that it's suitable protection, is taking on IDD obligations as well. So I think the sensible route is to leave it to the buyer to agree an apportionment from the seller. And another practical thing is, of course, that you need to make sure it's suitable to your lender, who may have particular requirements which the seller wouldn't be aware of. And also, we're finding increasingly now that sellers want their name to be noted on the policy, not just a generic description of a lender on there. So again, there's so many reasons now where it really should lie with the buyer's lawyer to arrange it, but at the seller's cost if you can get that sorted.
Yeah, 100% agree with what Robert said there. I think the buyer should do it, but I've got another reason that I've encountered in the past. Surely there's an incentive on a seller where a buyer requires an indemnity policy to get a policy. So there's an inherent danger that the seller just thinks, well, I'll tell the insurer anything on the basis that I'll get the policy, get the property sold, and that's me off the hook. And therefore, I think there's an inherent risk that a seller doesn't disclose everything that needs to be disclosed, takes out the policy. Buyer then has the benefit of the policy assigned to them, and then finds out at a later date that the policy is void due to something that the seller has or hasn't done. So that worries me, Robert, in addition to the points that you've made.
You know, I'd agree with you there entirely. I mean, it probably shouldn't say this given what our business is, but insurance should be a last resort in these cases. As a lawyer, you are doing due diligence, both as the seller preparing the title and the buyer investigating it. And if you can find a solution to it, then that's really, I think, your first call, isn't it? And that title insurance is there when there isn't another solution readily available to allow the transaction to proceed safely and speedily.
Yeah, good point. Good point. Okay, sorry for chipping in there, Stephen.
No, not at all. Thank you, and thank you, Robert. Thanks, Miriam. Actually, that question and the subsequent answer has opened a bit of a can of worms with some comments. I will just read a couple because it's quite interesting. Mark, who we spoke to earlier, said the problem with the buyer arranging the policy with an allowance is that some lenders, e.g. Santander, deem this as an incentive which must be reported.
Yeah, heard that before.
Brian makes the point and says buyer knows nothing about the property, so the statement of facts can only really be given by the seller. So just
yeah, well, there is that point, but again, that wouldn't preclude a buyer taking out a policy, but it's a fair point from Brian. Yeah.
Fantastic, excellent. So yeah, we just have a couple of questions left, which I think we will power through. Thank you to everyone who has stayed online to this point. Emma asks, have you received any information to support or warn against the use of e-reports?
Have I received any information warning against? Say again, sorry, Stephen.
I'm not sure what the context there is in terms of support or warn against, but I don't know if that's going to be a security issue or the validity of information. But.
Yeah. When we say e-reports, so we're talking about EWS ones for flats. If Emma can just clarify.
I don't know actually, but yeah.
Yeah, if it is, I always say to people, be careful with EWS ones because they're not fire safety certificates. And what you need to do, an EWS one is the beginning of a journey. There should be additional information produced by a landlord relative to the EWS one that will provide information for fire safety. And I think if there is fire safety issues, I think that's a valuation issue and a lender or surveying issue rather than a conveyancer's issue. So Emma, forgive me, I might be barking up completely the wrong tree, but if that's what the question related to, that would be my answer. Emma, if it was something else, drop me a note by email and I'll happily share my response with you, Emma, and also with Stephen and Robert and any of the delegates that are interested.
Fantastic, thanks. And Emma has to come back and clarify she meant electronic reports, but perhaps we can take that one.
Oh, electronic report. Sorry, thanks. So read the question again. I was up the wrong tree, Stephen. So read the question again, please.
Have you received any information to support or warn against the use of electronic reports?
No, I haven't. All I can say is that the market, and when I talk about the market, I mean suppliers to the conveyancing industry are all very interested in the idea of an electronic report, or not necessarily electronic report, the migration of data into a sort of standard framework, really is what I'm talking about. And no, I haven't seen any warnings relating to it. You know, to be honest, I think it's a useful thing. It isn't going to, it's not the sort of first step to artificial intelligence taking over the role of conveyancers. I think what it would require is a conveyancer spending more time looking at the report on title and being client facing. In other words, making sure that the report is understood by the client. So, I'm very open-minded about the use of electronic reports on title or reports on title that are having data migrated into it. I think it generates an opportunity for conveyancers to do this idea about personalizing the report and making sure clients understand it and get it. So thank you for that question, Emma. And sorry, as I say, I went completely in the wrong direction with the answer to start with. Thanks, Stephen. Next question.
Thank you. Yeah, I think we'll end it on this question. And so this question's from Beverly. Beverly asks, given that the new legislation provides that new leases can only have a peppercorn ground rent, we should be advising that if they are buying an existing leasehold with a ground rent, that this could be seen as less attractive to future buyers. The new legislation will create a two-tier system of leases.
100%. Great point, Beverly. And there's another point I want to make on that, Beverly, and that's this. That if I'm a landlord and I'm now left with a situation where I can't generate a return out of a ground rent on a new build, right? What I'm going to do is I'm going to look at my service charge and see if I can extract some form of management fee that generates a profit for me. So the fundamental principle with regard to service charge is its recovery of cost. But I think what we're going to see is landlords coming up with some fairly inventive provisions in residential leases that mean they're getting some form of management fee over and above what it's costing them to manage the building. And therefore, they're getting the ground rent via another route. But great point that Beverly made there. So thanks for that, Beverly. And thanks, Stephen. Stephen, I think that's just us for time. Just before we finish, unfortunately, my partner has a little dog that's been misbehaving. So she came into the webinar halfway through and has been misbehaving, and as I speak, has chewed all sorts of interesting things. So I'll have to tidy all that up. But if you can hear any squeaking or barking or nibbling, it wasn't me. It was the little dog who's going to have, she and I are going to have a little chat now, and hopefully we'll tell her that she's been very naughty and hopefully behave better next time. So if there were any noises at this end, Stephen, 1,000 apologies.
Not at all. Thank you, Ian. And yeah, on that note, thank you everyone. Thank you to everyone for attending today's webinar. If you have any other questions, please contact Ian or myself. There were a few outstanding there, so we will try and come back to those points separately as well. Once you leave today's webinar, you will receive an automated message from GoToWebinar. If you respond to this email, the replies come directly to me, and I can send any questions or feedback on to Ian or Robert, or answer them myself, of course. You will receive a separate email from my colleague, Robert Kelly, which will contain the slides and the notes of today's session, and also a link to the recording as well. On behalf of Stewart Title and Ian Quayle, thank you for joining us today, and have a great rest of your day, everyone. Thanks and goodbye.